The court is in session in the case of State of Juristan versus Armahan Randhawa. The prosecution, you may proceed.
Good afternoon, Your Honor. My name is Juris acting on behalf of prosecution, along with my co-mooter Shagufta Zohar and the legal researcher Juris, along with my co-mooter Shagufta Zohar and the legal researcher Anas Khan. Your Honor, I will be assisting the court with the first three issues, and the next two issues will be assisted by my co-mooter Shagufta Zohar. Your Honor, the very first question arising from the facts, that is whether Juristan has the jurisdiction to trial this matter. And the question which I have is yes, Juristan is competent to trial this matter. Your Honor, we can following these following points. Number of point is location of the offense. Your Honor, the offense has been committed around the 250 nautical miles, which is the exclusive economic zone. Your Honor, Article 73 of UN clause states that all laws and authorities can be implemented in exclusive economic zone. Your Honor, even though if it is exclusive economic zone, but according to the Article 73 UN clause, the coastal state may, in the exercise of its sovereign rights to explore, exploit, conserve and manage the living resources in the exclusive economic zone, take such measures including boarding, inspection, arrest and judicial proceedings as may be necessary to ensure compliance with the laws and regulations adopted by in the conformity with this convention. Your Honor, all laws of Juristan are enforceable. Because the offense has been committed around 250 nautical miles. So Juristan has the jurisdiction according to the 73 UN clause. Juristan has the jurisdiction to trial this matter without any doubt. Your Honor, sir, when it comes to international criminal jurisdiction, international law proposes various theories. The number first theory is theory of territoriality. Your Honor, theory of territoriality tells that on the basis of national security, if any state wants to trial any person irrespective of nationality, that state can take the cognizance of that case. And the second theory, which is theory of extraterritoriality. Your Honor, theory of extraterritoriality tells that if any state wants to trial the person irrespective of nationality and jurisdiction, that state trials the matter, so there is nothing wrong with this. Your Honor, there's another theory of universal jurisdiction. The theory of universal jurisdiction suggests that offense is universal in nature and also against of humanity. So if any state take cognizance of the offense, again there is nothing wrong with it. Your Honor, if you have any question, may I move towards second issue? Your Honor, the second issue is whether it was murder considering the circumstances or not. Yes, Your Honor, it was murder. As you know, to know that it is amounting to murder or not, we look for two main states of mind, that is ectasia and mens rea. As per the facts, when Armaghan Randhawa was about to kill Dilozen Qazalbash, Feroza Bill hold the legs of Dilozen Qazalbash. If he struggled, pushed his penknife into Qazalbash's jugular vein, consequently Qazalbash died. So here Feroza Bill and Qazalbash, here they are having both mens rea and ectasia, and these are the main ingredients of 300 of section of GBC.
Sir, so you have told us that it was murder and motive is the main ingredients for any offense to be constituted. So their motive was not murder, the motive was to make one part of the body flesh so that they can survive the journey. So do you think it was murder, or there might be other charges which they can be charged of?
Sir, as per the facts, Dilozen Qazalbash he pushed his penknife into Qazalbash's jugular vein, consequently Qazalbash died. This death was the consequence of that action which Qazalbash did. This was it here clearly mentioned that consequently Qazalbash died. So this is the consequence. This death is the consequence of the action of Armaghan Randhawa. So it falls into 300, section 300. So if you do not have question, may I move towards matter number 3. Number third issue is whether only Armaghan Randhawa is liable for the killing of Dilozen Qazalbash. Your Excellency, it is more than clear that not only Armaghan Randhawa is liable but also Feroza Bill and the 3 members. As per the facts, when Armaghan Randhawa was about to kill Dilozen Qazalbash, I am again pointing out that point, killing Qazalbash, Feroza Bill hold the legs of Dilozen Qazalbash. If he struggled, pushed his penknife into Qazalbash's jugular vein, consequently Qazalbash died. Here, Your Honor, Feroza Bill helped Armaghan Randhawa to kill Qazalbash by holding his legs. Clearly here mentioned that Feroza Bill hold the legs of Feroza Qazalbash to kill him. So here Feroza Bill helped Armaghan Randhawa. Here is, so both of them are liable. Is section 34. Saying X done by several, section 34.
Can you clear me the point? As you mentioned, section 300 GPS.
Yes.
Cannibalism is punishable under PPC or GPC?
No, sir. There is no explicit mention in cannibalism is unlawful. No explicit mention in JPC.
Then how can you rely on section 300 or 302?
Because it was not only cannibalism, it was murder. Murder cannibalism. So murder is absolutely unlawful in JPC. It was murder cannibalism. Dilozen Qazalbash was not died yet. It was murder. So it was murder cannibalism. It was not only cannibalism, it was murder cannibalism.
If an offense is not mentioned in GPS, what remedy do you have then?
Can you pardon?
There is no punishment specifically mentioned in about cannibalism in your PPC. Then
Yes.
how can you get?
There is no mention any punishment, but there is clearly mentioned the murder punishment. 302. So all the aggregates fall of 302. So the court of Juristan can give punishment to them according to 302. Your Honor, may I call my commuter to assist the court further? Thank you so much.
गुड आफ्टरनून हियर आवाज़ आ रही है?
It is very slow.
माइक का It's myself, Shagufta Zahoor, on the behalf of prosecution, along with my co-mooter Rahis Ahmed.
Kindly can you speak a little bit loud?
Yes, ma'am. Now it's fine.
Yeah, now it's
The issue is whether cannibalism is lawful under the theory of necessity or not. Your Honor, under the theory of necessity, certain actions that would typically be considered illegal may be justified if they are the only means to prevent a greater harm and danger. However, in the case of cannibalism, it's generally not considered lawful under the theory of necessity due to several strong ethical and legal arguments. Your Honor, it's the violation of human rights. Your Honor, every individual has the right to live and bodily integrity, which means that taking someone's lives even in desperate a situation violation their basic human rights. And I have a judgment on this Regina versus Dooley and Stephen. Your Honor, I want to draw your attention on the health. Yes, it's a murder, Stephen and Dooley to be sentenced to death. Your Honor, the case is relevant with this Armaghan Randhawa and Dilozans. Your Honor, ये सिमिलर है इसके कि दिलोज़ैन और दिलोज़ैन का ज़ालबाश जिस तरह उसकी जिस तरह वो कैनबलाइज्ड हुआ, द केस इज़ रेलिवेंट विद दिस. सिम इस केस में भी ऐसा हुआ था कि 4 क्रू मेंबर्स थे जो कि हाई सी में फंस गए थे और उन्होंने भी अपने एक क्रू मेंबर का अपने एक क्रू मेंबर को कैनबलाइज्ड किया था. एंड द नेक्स्ट पॉइंट, in that case cannibalism was strongly, yes.
Can you point any legal point, any provision of law which says cannibalism is prohibited? If there is no legal provision regarding it, so it is implied to presume that it is lawful. When law is silent regarding anything, so it is presumed that it is lawful.
Sir, but laws always prevail on the theories.
I am unable to apprehend your answer.
Sir, translate into.
मेरा सवाल था कि कैनिबलिज्म कोई लॉ की ऐसी प्रोविजन नहीं है जिसने कैनिबलिज्म को प्रोहिबिट किया है.
Yes, sir.
सो अगर कोई चीज़ प्रोहिबिटेड नहीं है तो इट मींस दैट इट इज अलाउड. इम्प्लाइडली तो ये प्रिज्यूम किया जा सकता है.
Yes, sir.
क्या कोई ऐसी प्रोविजन है कैनिबलिज्म के बारे में?
Sir, it's a ethical wrong.
What?
Sir, it's a moral and ethical wrongful act.
There are many things which are moral and ethically wrong, but they are not punishable. They are values, moral values, ethical values, but it is not. We do not presume that अगर हम ऐसा कुछ गलत कर देते हैं तो उससे फिर हमें सजा भी हो सकती है. एथिकली शायद गलत होगा कि मैं किसी की कॉल नहीं उठाता, पर इससे सज़ा तो नहीं होगी ना मुझे?
Yes, sir. But the theory of necessity is purely administrative and judicial in nature. It has nothing to do with this killing a human being.
Can you assist the court regarding the time and place of occurrence?
What, sir?
क्या जो टाइम के कब ये ऑफेंस कमिट हुई है, इस पर कोर्ट को असिस्ट कर सकते हैं या आप इस पर असिस्ट कर सकते हैं कि ऑफेंस कब डेट बता सकते हैं, प्लेस बता सकते हैं?
Within 11th of June 2023 to 13. 11 to 13.
जो वेपन के कोई रिकवर हो चुका है,
कौन सा वेपन, सर?
ऑफेंडर से कोई वेपन रिकवर हो चुका है?
No, sir.
Counsel, your time is up.
Thank you, sir.
The defense counsel, you may proceed now.
Good afternoon, Your Honor. This is Mahira Sobat, first mooter from defense side. Our second mooter is Mr. Hasnat Hamid and a legal researcher, Mrs. Marias. We are appearing on behalf of defense in the case of State versus Armagan Randhawa. I'll be argumenting on first two issues of the instant case, and the rest of the issues will be argumented by Mr. Hasnat Hamid. So, as the court is acquainted with the facts of the instant case, may I proceed towards the issues of the instant case? Thank you, Your Honor. So, Your Honor, the first issue of the instant case is whether the court of Juristan has jurisdiction to try the case or not. Your Honor, prosecution has failed to prove the case beyond any reasonable doubt because it includes the aliens. Therefore, the court of Juristan lacks the jurisdiction, and I urge this honorable court to refer the case to the court having appropriate jurisdiction. Furthermore, the Armagan Randhawa and Dilrozain Kazalbash are the nationals of state of Naina, which attracts the active nationality principle of international law. So here I would like to stabilize the instant notion upon a reliance, that is JLD 1972 SC 271. So I request this honorable court to come the first page of the instant judgment, that is the highlighted portion. With the prior permission of this honorable court, may I read the statement of the judgment? If a mandatory condition for the exercise of a jurisdiction before a court, tribunal or authority is not fulfilled, then the entire proceedings which follow become illegal and suffer from want of jurisdiction. Any order passed in continuation of these proceedings in appeal or revision equally suffer from illegality and are without jurisdiction. So, Your Honor, this judgment is relevant in the instant case because it says that the necessary condition must be fulfilled to exercise the jurisdiction, and here the necessary condition is nationality. So that must be taken by this honorable court, and the case therefore must be referred to the court having appropriate jurisdiction in the instant case. Furthermore, the term of the service of the crew members expired because that was for 1 year, and it is clearly mentioned in the facts of the case that after 1 year it will be automatically terminated. Therefore, the section 4 of Juristan Penal Code becomes irrelevant in the instant case. Furthermore, I hope that I have advanced my arguments on the instant case beyond reasonable doubt and to the satisfaction of this honorable court. May I proceed with the second issue of the instant case, Your Honor?
As per the jurisdiction is concerned, the para number 10, I think, will come to 1. Para number 2.
Para number 2
Yes.
of the facts of the case.
Yes, facts of the case.
It says according to UNCLO's
The fourth line, please.
fourth line. It says Armagan Randhawa and Dilrozain Kazalbash from Naina for exploring natural resources in the sea. They have expertise in marinology and oceanology and international law. They have been appointed for a period of 1 year, and their contracts will be automatically terminated.
Can I stop?
Yes, sir.
Entire page. It says it is the United Nations Convention on the Law of the Sea this area is extendable to 360 mm.
Yes, ma'am.
The murder is probably done in 250 mm. So it is the jurisdiction of this court.
So I refer you to the para 6 of the instant facts of the case and line 2. Sorry. Somewhere kidhar hai? So I refer this court to the para 4 and last line.
Yes.
Here it is clearly mentioned that the ship was floating in the sea, somewhere in the sea. This somewhere does not show that the occurrence occurred within the territory of Juristan, Your Honor, and it must be taken into the consideration by this honorable court.
And the CRPC section 2 also is very clear about if offense is committed within the limits and beyond the limits of the Pakistan, and if it is related to the Juristan.
Your Honor, this word somewhere negates the section 2 of Juristan Penal Code. It negates the jurisdiction of Juristan Penal Code because it says that punishment for offences that are committed within the territory of Juristan, but this somewhere signifies that it was not committed in the Juristan but somewhere in the sea.
That's why the section. Okay, you may proceed, please.
So may I
Madam, you have said you have asked for JPC, okay? So in section 3, isn't it mentioned specifically any person liable by any Pakistani to be tried for any offence committed beyond Pakistan?
that too includes,
Section 3.
but sir, that is about when the person is working for the Juristan. Here person is not working for the Juristan because he is not in the service at the time of the occurrence.
So if someone is not working for the Juristan, they can commit any offence.
Then they will be tried by their own state. If they are citizen of any other state, then that citizen, according to the active nationality principle, is
So if someone
entitled.
commits any offence in the jurisdiction of Juristan, it might be in C, okay? So can they be tried in Juristan or not?
Then there is a condition. If they are in the service of the Juristan or they are on the vessel that is registered under the Juristan, then they will be tried. Otherwise, the active nationality principle will be attracted.
So you are implying that any person who is foreigner has a license to commit offence in Juristan if they are not employed by Juristan.
No person has the license to commit offense, but still, if they commit, then they will be liable. If they are in the service of the Juristan, then Juristan can try. If they are not in the service of the Juristan, then they will be tried by their own state.
You are saying service, I am unable to apprehend what you are implying. Service, so I have to be in the service of Pakistan. Service in what?
Service is that he is under the contract with that state.
So if a foreigner comes in Juristan and he can commit offence, but he cannot be tried in Juristan.
Not in Juristan, Your Honor.
So isn't it against natural law?
It depends upon the circumstances, what type of crime he is committing, Your Honor.
For the sake of argument, for the sake of argument, if cannibalism or murder is not punishable in a state, for the sake of argument, in UK, and a national comes in Pakistan, and he is not in the service of Pakistan, as we have said, does he?
That comes under the universal principle of international law.
So
That
he
will
cannot
be.
be tried in Juristan.
That can be tried by the Juristan if under the universal principle of Juristan if offense of murder is committed.
So universal principle. Okay, madam, you can proceed.
Thank you, Your Honor.
Can you define active nationality principle from the nation?
Yes, sir. Active nationality principle of international law says that a country is permitted to exercise the jurisdiction over its nationals wherever in the world they may act. So, Ji?
This is just a nation.
Yes, Your Honor. It is the fundamental principle of United Nations Human Rights Council.
यहाँ पे अगर ये एक्टिव नेशनलिटी प्रिंसिपल है बेस पर तो फिर व्हाट इज नेशनल नेशनलिटी प्रिंसिपल?
Sir, that is not the contention of my memorial. Thank you, sir. So, second question is whether the killing of Dilruzin Khazalbash was murder considering the circumstances of the case or not. Your Honor, absolutely not. Because the killing of Dilrozen Qazalbash cannot be considered as murder, because it lacks the essential ingredient of Section 300 of Juristan Penal Code, that is intention. This intention can be termed as mens rea. I would like to emphasize on the word mens rea. Mens rea coupled with a Latin phrase that is actus reus non facit nisi mens sit rea. This says that there can be no crime without a guilty mind. And there are certain exceptions to the mens rea, but these exceptions does not include murder. Therefore, there is a relevant judgment in this regard. That is JLD 1992 Peshawar 1 to 5C.
Ma'am, you are implying that for the sake of argument, if I want to it, if I want him in a cannibalism or someone, I want to chop a hand of a person, so my intention is not to murder him, but he dies subsequently. So, am I liable for murder or not?
Sir, you will be liable for murder, but not under Section 302 of Juristan Penal Code, as there are certain essentials for a person to be liable under Section 302. Here, Armagan Randhawa is not liable to be punished under Section 302 of Juristan Penal Code because it lacks the essential ingredients of murder.
So, is he liable?
He is not liable under Section 302 of Juristan Penal Code.
Is he liable for any other provision of JPC?
So that is to be decided by this honorable court.
So, this honorable wants your opinion. So, you are able to assist this honorable.
Keeping in view the arguments, we can assist further this court.
Okay.
As per your this authority, this is against of your stand.
Your Honor,
Whenever you present an authority, just it is not the one put of this acute of this part, but it is for the judgment. I think you are not called to do the old judgment. The judgment is against you.
Your Honor, can you please explain me how it is against my contention?
It is not only about the intention, it is rejected this point because they applied for the bail and finally the bail has been rejected. If the bail is rejected, it means the claim of the intention in all the parts of the claim of the accused has been rejected.
Okay.
But whenever you present an authority, just go through the old judgment.
Okay, Your Honor. I like to support my contention with another judgment, that is 2009 SCMR 929. Your Honor, I would like to refer you to the para 1 of page 2. Your Honor, it is clearly established in this judgment that the act of Armagan Randhawa is justified because it was to preserve the lives of other crew members. It has been established in this that the principle are that conduct of accused during the whole transaction and his presence at the spot should be bona fide. And here it is clearly mentioned in the facts that Dilrozen Qazalbash was himself very motivated by the services of the Armagan Randhawa for the humanity, and he being the great scientist. So therefore the mens rea of this, in this case of the Armagan Randhawa is established, not established by the prosecution.
क्या जिन केसेस में मेंस ना हो तो वहाँ पर सिर्फ ड्रग्स हो जाए तो ऑफेंस करिए?
Sir, indeed that is an offense, but to hold a person liable under Section 302 of Juristan Penal Code, a court must consider the mens rea of a person. If that is alleged, then he is not liable to be punished under Section 302 of Juristan Penal Code.
अच्छा, आप इस बात पे स्ट्रेस करते हैं कि यहाँ पे मेंस नहीं
नहीं है sir,
नॉट लाइबल.
not liable sir.
What about conduct crime?
Sir, sir, may I beg your pardon please?
आप ये यहाँ पे मेंस नहीं है, यहाँ से ऑफेंस कमिट नहीं है.
Not liable. I am saying that he is not liable under Section 302 of Juristan Penal Code because he lacked mens rea, as prosecution has charged Mr. Armagan Randhawa under Section 302 of Juristan Penal Code. So I believe that I have argumented in the instant notion to the satisfaction of this honorable court. Furthermore, I request the permission of this honorable court to allow Mr. Hasnad Hamid to proceed further with the case. Thank you.
Good afternoon, Your Honor. I hope that my co-mooter, Ms. Myra Sobat, has advanced her arguments beyond any reasonable doubt. I will be argumenting on the remaining three questions. The third question, which arose from the facts of the case, is whether only Armaghan Randawa is liable for killing of Dilruzain Qazalbash or not. Your Honor, as per the facts and circumstances of the case, Armaghan Randawa is not liable for killing Dilruzain Qazalbash. As we know from the facts of the case, Dilruzain Qazalbash was already in coma. He could not drink, he could not eat. He would eventually die. But killing him before his natural death would mean blood to drink and flesh to eat. And this act is justified under the principle of utilitarianism.
Gentlemen, can you assist the board regarding that specific period of coma?
Sir, it is not mentioned. Prosecution has failed to mention the specific criteria time of the coma. But however, it is said that he fell into coma somewhere around 11th to 13th of the date. Sir, I would like you to please refer to the facts of the case. Sure, sir. Okay. Sir, the second thing is that the case of the prosecution is missing the important ingredient of the crime, because under section 300 of Juristan Penal Code, the instant case is missing the most essential ingredient, which is intention. Your Honor, in order to constitute the crime of Qatl Ahmad, it is important to prove guilty mind. It can better be explained through the maxim actus non facitrum nisi mens cetria, which says that an act does not make a man guilty unless there will be a guilty intention. Hence, the act itself does not constitute the guilt unless done with the guilty mind.
गिल्टी इंटेंशन नहीं है तो क्या स्ट्रिक्ट लाइबिलिटी ऑफेंसेस सीरियस लाइबिलिटी ऑफेंसेस सारे एग्जेम्प्टेड हैं?
Sorry, Your Honor, pardon, Your Honor. Could you please repeat the question?
You have 5 minute notes to explain your points.
Okay. Your Honor, section 300 of Juristan Penal Code defines Qatl Ahmad, and one of the most essential ingredient is intention to kill. However, according to the facts of the prosecution, the case does not attract guilty intention. Hence, we cannot say that it falls under section 300 of Juristan Penal Code. And as I mentioned earlier, that it can better be proved according to the maxim actus non facitrum nisi mens cetria, which says an act does not make a man guilty unless there is a guilty intention.
Sir, you have talked about intentions.
Yes, Your Honor.
If you chopped up one's hand or if you cut one's throat, so in all probability he will have to die.
Yes,
so
Your
isn't it enough for intention?
Your Honor, we are
Their
discussing.
all intention was to murder him and eat his flesh.
Okay. Your Honor, I would like to refer you back to that principle of utilitarianism, because it is justified under principle of utilitarianism, because he will eventually die. However, killing him before his natural death will mean that the team will get blood to drink. However, in the natural death, there will be no blood. So it is.
We are here talking legally speaking, so we should stick to the law.
Yes, Your Honor.
So you have said that their intention was not there. So I have asked that they have cut their throat.
Yes, Your
what
Honor.
else kind of intention do you need? This is
Sir-
open and shut case. They are guilty of the offense.
Sir, it was justified intention, and according to section 35 of Juristan Penal Code, there must be guilty intention. However, the principle of utilitarianism justify this intention.
Their primary goal was to kill him, and their secondary goal was to eat his flesh. So killing was their intention, which is punishable under 302
It
and
is
300 and explained it.
But it is also mentioned, he just asked him that we are going to kill you, we are going to eat you. What was that?
Your Honor, if we refer to the facts of the case, Dilruzain Qazalbash agreed to sacrifice his life for the survival of others. It has been.
About his refusal.
But later on, when the Firoza Bill suggested the drawing of lots, again he agreed on that case, after which he fell into the coma. So he did not deny the drawing of lots.
Before going to coma, he refused. He likes his life. He loves his life.
Yes, Your Honor.
Taking life doesn't mean the intention.
Your Honor, again I would like to refer to the facts of the case, that after denial, when Feroza Bill suggested drawing of lots, Dilrozain Qazalbash did not deny and he participated in the lots, after which his name came and he fell into the coma, which clearly indicates that he intentionally entered into those lots. So he did not deny. Second thing, I hope I have presented my arguments beyond reasonable doubt. So hence, according to the arguments, Armaghan Randhawa and others are not liable for killing Dilrozain Qazalbash. The fourth question, which arose from the facts of the case, is whether cannibalism is lawful under the theory of necessity or not. Indeed, Your Honor, it is justified, as according to the customs of the sea, it has been practiced for several years that whenever a ship used to get stuck in the sea, the crew members would kill one of the crew member and the other would eat the meat for the survival. Yes, Your Honor.
आपने custom to CC knowledge.
Yes, Your Honor.
Legal event certificate.
Yes, Your Honor.
Can you assess the court?
Yes, Your Honor. I would like to mention some few cases. Your Honor, it has been a well-established principle. It was encouraged in the book written by William Ahrens, The Man-Eating Myth. Second, it was observed in the case St. Christopher case in 17th century, and it was also encouraged in the case Mary versus Exine 1874.
Counsel, your time is up.
Your Honor, I would like to request few minutes so that I can recite my prayer clause.
It's already 20 minutes, I think.
Just few seconds, sir.
Few seconds.
Yes, sir. For your prayer clause. Okay. Keeping in view the above mentioned arguments, authorities, and principles, it is my request. It is respectfully prayed from this honorable court to please refer the case to the court competent to adjudicate the matter and dispose of the matter in issue. Second, discharge Mr. Armaghan Randhawa from the charges levied under section 302 and 34 of Juristan Penal Code, and at last make any other order which this honorable court deem fit to be passed in the interest of justice, equity, and fair play. Thank you, Your Honor.
The prosecution, you may proceed for rebuttal. And you have only 1 minute.
Your Honor, the defense counsel failed to convince the court by providing the accurate laws to convince the court that which state is having jurisdiction. Secondly, they gave the example of necessity. We know that necessity by nature is political and administrative. It doesn't mean that to follow these necessities you...
But if Justice Ashim Kakad was here, we will be replying. Leave the court convenience to us. It is on our way of whether we are convening.
But they didn't provide
Yes.
any specific judgment case laws.
Whether we convinced with their points or not. It is just the remark of Justice Ashim Kakad.
But to me, they didn't.
Give statements of their relative.
Your Honor, they said that it was not murder. How it was not murder? And they are saying they were not having intention. Your Honor, they were planning for many days. So how it was not? They were not having intention. They were having mens rea as well and extra as well because they were preparing this to kill Dilrozain Qazalbash.
Counsel, your time is up.
Thank you so much.
The defense counsel, you may proceed for rebuttal. And you have only 1 minute.
Your Honor, I rebut the argumentation done by the prosecution. They mentioned that the period of service was expired at the time of the occurrence. It means they themselves are admitting that the section 4 of Juristan Penal Code makes the jurisdiction of Court of Juristan irrelevant here. Furthermore, the prosecution said that the act included actus reus and mens rea, but they did not proved with the proper argumentation the mens rea of Armaghan Randhawa, and they failed to assist this honorable court with the proper authorities that are to be relevant in the instant case. Furthermore, there are many dents and doubts in the prosecution case, so I urge this honorable court to kindly discharge Mr. Armaghan Randhawa with the instant charges. Thank you, Your Honor.
Please all rise. The court has adjourned for 5 minutes.